Okay, we have a couple of them. Sir, I think 8-7 तो हो ही गए हैं. I've given a notification. We can start.
शुरू करते हैं. Okay. Very good evening, all. Am I audible?
Yes, sir.
Yes, sir.
Okay. Today we finished 498A, and today I'm going to take IPC 406, which is the second most commonly used penal code in matrimonial disputes, and along with other few which are also randomly instituted, so on and so forth. For example, 354, which is the brother-in-laws and father-in-laws are generally implicated in 354. Section 377, with penal punishment for 377. 377 is unnatural sex. Punishment is up to 10 years. So why do you think 377 is invoked in matrimonial disputes? What do you think is the benefit? Who can tell me?
Hello,
Yes, sir.
Just unmute yourself and answer whoever wants to. Don't worry about these hands. Yeah.
Sir, the 377 can be tried before the session court rather than the judicial magistrate.
Okay.
So the ABA must be in the picture then.
No. So what is the basic purpose of invoking 377?
Sir, उसे prove करना और disprove करना दोनों ही बहुत मुश्किल है. तो
It is just an allegation level.
और बताइए.
Hello.
हाँ जी. It's
Sir,
not a
am I
section tribunal. It is magistrate. Okay.
Hello, sir. Am I audible?
Yes, you are.
Sir, actually, I believe what the thing is that there is, I believe, the requirement of a notice in 41D or A, I believe. So that has to be done and arrest cannot be made. So that is why the policemen, what they do is they unnecessarily add 377 because the punishment is higher and so that they can arrest the person. Because I believe the minimum punishment is 10 years, I believe, for 377.
Very good. Very good. That's the answer.
Yes.
So the purpose of invoking 377 in matrimonial disputes is you can bypass Arnesh Kumar guidelines. Okay, police one way or the other is looking for ways to bypass whatever precedents Supreme Court sets in order to save people, but their vested interest goes away with those guidelines, correct? So in order for them to find ways to harass people, get bribes, is invoking a section which is going to basically coerce the men, other people to give them money. So 377 is one of them. So 377 is invoked on husbands. Others are 354, which is generally not invoked on husband. Why? What is 354? Outraging modesty of a woman. Okay. So इसमें आपको wife होना जरूरी नहीं है. You just need to be a woman in order to get outraged. We'll get into it. 376 is another section which is invoked in certain states in order to coerce the husband side's family to settle. 376 sometimes is invoked in a way that the wife would say, look, he promised me to get married. However, he did not marry me, or our marriage was a sham, or I was believing it was a marriage. So उसमें 493 section होता है. Cohabitation caused by man deceitfully inducing a belief of lawful marriage. 493 is one section. 494 is one of the partners is married, husband is married, wife is married, so the opposite party is going to sue you in 494. 495, 496, 497 adultery, which is not a penal offense anymore. It's been struck down by Supreme Court. पहले adultery use होता था, अब इसमें कोई ज़्यादा energy नहीं लगा था. 498 we have already discussed. 499, 500 defamation is also used in matrimonial disputes. 3 hurt, जिसमें 323, 324, 323 तक ही stuck रहते हैं. But अगर acid attacks होते हैं, कोई grave injury हो गई, तलवार उठा के ले आए, कोई ये सब कुछ हो गया, वो बहुत rare cases होते हैं. उसमें voluntary causing grievous hurt by dangerous weapons is 324. 325 is punishment of grievous hurt. So it doesn't matter what the weapon is. So we are going to touch them in order to get an idea what is happening elsewhere. Now, coming back to our main section, which is IPC 406. Okay, somebody please read 406.
Yes, sir. One doubt here, sir. Can I ask?
Please, sir.
Sir,
इन सेक्शन से रिलेटेड मत करना, मैं इनको अभी पढ़ाऊंगा आराम से. अभी तो मैं सिर्फ बता रहा हूँ, पिक्चर दे रहा हूँ.
no, I'm just asking a generic query, sir.
Okay.
Sir, a lot of sections which you discussed, which the police, levels the charges, basically for their own vested interest to take out the money and all, as I could gather. Now, supposingly, one of the parties, okay, chalo, they are asking money, I'll give the money. How would they drop the charges? Would they go in under 169, not have sufficient evidence found before filing the charge sheet?
Correct.
Initially, they will frame charges to, fleece the chap, and if gives the money, then they will invoke 160. Thank you.
That's a normal course of action.
Right.
Yes, who's reading 406?
Tandon sir, are you reading? Okay.
Taking out the section, just give me 1 minute. Sir, shall I read? Punishment for criminal breach of trust. Whoever commits criminal breach of trust shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. Classification of offense: punishment, imprisonment for 3 years and fine, or both, cognizable, non-bailable, triable by magistrate of the first class, compoundable by the owner of the property in respect of which breach of trust has been committed, with the permission of the court.
Okay. इससे पहले आप 405 पढ़िए. आगे 405 पढ़िए.
405. Just criminal breach of trust. Whoever being in any manner entrusted with property or with any dominion over property dishonestly misappropriates or converts to his own use that property, or dishonestly uses or dispossesses of that property in violation of any direction of law, prescribing the mode in which such trust is to be discharged, or of any legal contract, express or implied, which he has made touching the discharge of such trust, or willfully suffers any other person so to do, commits criminal breach of trust. Explanation 1. A person being an employer of an establishment, whether exempted under section 17 of the employees, just a second, my battery has gone. I'm just
तो ये क्या बोल रहा है? Whoever being in any manner entrusted with the property. Okay, so word is entrusted. Or with any dominion over property. आपकी कोई ना कोई उसके पास domination होनी चाहिए. फिर second part में बोल रहा है dishonestly misappropriates or converts to his own use that property or dishonestly uses or disposes of that property in violation of any direction of law prescribing the mode in which such trust is to be discharged, or of any legal contract, express or implied, which he has made touching the discharge of such trust, or willfully suffers any other person to do so, commits criminal breach of trust. Explanation पढ़िए sir.
Explanation. A person being an employer of an establishment, whether exempted under Section 17 of the Employee Provident Fund and Miscellaneous Provision Act 1952, who deducts the employee's contribution from the wages payable to the employee for credit to a provident fund or family pension fund established by any law for the time being in force, shall be deemed to have entrusted with the amount of contribution so deducted by him, and if he makes default in the payment of such contribution to the said fund in violation of the said law, shall be deemed to have dishonestly used the amount of the said contribution in violation of direction of law as aforesaid. Explanation 2. A person being an employer who deducts the employee's contribution from the wages payable to the employee for credit to the employer to the employee's state insurance fund held and administered by the employee's state insurance corporation established under Employees State Insurance Act 1948 shall be deemed to have been entrusted with the amount of the contribution so deducted by him, and if he makes default in the payment of such contribution to the said fund in violation of the said act, shall be deemed to have dishonestly used the amount of the said contribution in violation of direction of law as aforesaid.
Illustrations है आपके पास?
Sorry. My battery is troubling me. Just
You have. I'll ask somebody else. Harish, are you there? Do you have the IPC?
Yes, sir. Yes, sir. I have.
Illustrations पढ़ो इसकी.
Okay. Yes. Illustration A. A being executor to the will of a deceased person dishonestly disobeys the law which directs him to divide the effects according to the will and appropriates them to his own use. A has committed criminal breach of trust. B. A is a warehouse keeper. Z, going on a journey, entrusts his furniture to A under a contract that it shall be returned on payment of a stipulated sum for warehouse room. A dishonestly sells the goods. A has committed criminal breach of trust. C. A, residing in Calcutta, is agent for Z, residing at Delhi. There is an express or implied contract between A and Z that all sums remitted by Z to A shall be invested by A according to Z's direction. Z remit a lakh of rupees to A with directions to A to invest the same in company's paper. A dishonestly disobeys the direction and employs the money in his own business. A has committed criminal breach of trust. D. But if A, in the last illustration, not dishonestly but in good faith, believing that it will be more for Z's advantage to hold shares in the Bank of Bengal, disobeys Z's directions and buys shares in the Bank of Bengal for Z instead of buying company's paper, here thought Z should suffer loss and should be entitled to bring a civil action against A on account of that loss, yet A, not having acted dishonestly, has not committed criminal breach of trust. E. A revenue officer, is entrusted with public money and is either directed by law or bound by a contract, express or implied, with the government to pay into a certain treasury all the public money which he holds. A dishonestly appropriates the money. A has committed criminal breach of trust. F. A carrier is entrusted by Z with property to be carried by land or by water. A dishonestly misappropriates the property. A has committed criminal breach of trust.
Okay. Do you have this comments between criminal breach of trust, meaning and extent?
No, sir. After illustration, I have a 406 section.
ठीक है. Okay. It must be proved that the beneficial interest in the property in respect of which the offence is alleged. Take 1 second. Am I audible? Am I audible?
Yes, sir.
Yes, sir.
Okay, sorry. All right. So, guys, we have superficially read what criminal breach of trust is. Criminal breach of trust has a very wide ambit and it can be used in lot many contexts. But we will stick to how it is used in matrimonial disputes. I, on the first or second session, explained you the concept of stridhan, dowry, and gifts. Okay. So, can one of the participants who are regular students tell me what is stridhan? Mr. Tandon, Mr. Gopal, Mr. Advocate Nilesh, any of you?
The Sridhan is basically what the parents give at the time of the marriage from their own willingness.
Okay. To who?
To the bride.
Okay. Who else can give stridhan?
In fact, if I'm not wrong, even the parents of the groom, out of their own willingness, may give something to the bride at the time of marriage.
Yes. Guys, please put your cameras on. We have very few people anyway. I don't want to talk to dummies.
Basically, whatever is given, out of love and affection by parents or in-laws at the time of marriage to the bride, everything belongs to her as a part of Sridhan.
Correct. So stridhan can be given by parents of the bride, can be given by the parents of the husband, can be given by the brother of the husband, can be given by the husband, can be given by the brother of bride, can be given by the brother, relatives or friends of the bride. Anybody, any damn person in the world giving anything to the bride in the name of the bride, in the hands of the bride is considered stridhan. Okay? Anything given by the wife to the husband, to the in-laws as a gift is not stridhan. So understood? Anything which is coming to the bride in the name of the bride is stridhan. Stri is lady, dhan is uska dhan. ठीक है? अब stridhan का वो क्या करती है? सिनारियो शुरू होता है, आपकी शादी होती है, आपकी वाइफ के पेरेंट्स ने, उसके रिलेटिव्स ने, उसकी मौसी ने, उसकी चाची ने, whosoever is in her family happens to give her gifts to her कि हमने सोचा था तेरी शादी होगी जब तू बड़ी होगी, मैंने इतने पैसे जमा किए थे, नानी ने सोचा था कि जब तेरी शादी होगी तो मैं तेरे को 9 लाख का हार दूंगी, तगड़ी दूंगी, जो भी दूंगी, मैंने तेरे लिए बचा के रखा था. ऑलराइट, दिस इज व्हाट नानी सेंटिमेंट इज. तो नानी आती है शादी में, वो उसको एक हार पहना देती है. आगे बात समझ में? नानी किसकी है?
I just checked the definition of dowry in Dowry Prohibition Act. Okay, so in Dowry Prohibition Act, it states that the valuable security that is to be given should be agreed to be given. So freedom would be a voluntary act, right? It should be a voluntary act, otherwise it becomes dowry.
Correct.
Okay, all right, sir.
That's what we are saying. It's given to the bride. It's not given to the family of the husband.
Exactly. By okay, I guess you'll be covering dowry next. So
We are only focusing on Sridhan right now. What can be recovered?
Yeah. Okay, sir. Thank you.
All right. Harish, you want to say something?
Yes, sir. I only had to say this only, that is the only difference between dowry and Sridhan. That Sridhan, the sole control, or it is devoted for the bride, and the dowry is something which is for the in-laws, basically. In
Correct.
simple terms.
Okay. You may put your hand down. All right. Now, Sridhan, so I'm just giving you a scenario, understanding the practical context. Now, the dadi of the husband's dadi is also there. So, okay, understood. She's an old lady, and this husband happens to be the only pota of her grandson or great grandson. So dadi is emotional, and she says, I wanted to see my grandson's marriage before I die, or great grandson's marriage before I die. This was my last dream on earth, and I wanted to. I had kept this 10 lakh gold ornament for my great grandson's wife. Understood the background? Come, my dear, I'm going to give it to you now. So Dadi is there, and husband is there, and husband's mummy is there, and bride is there, and everyone is there. So Dadi, it's some kind of an occasion, some kind of a function. It's either marriage, pre-marriage, or whatever it is. So now what Dadi does is she opens her locker and she gives this 10 lakh worth rupees har to the bride in front of the family members. हो गया? तो अब क्या हो गया इस हार का मतलब?
It becomes a Sridhan.
It becomes a Sridhan. Up then, because the mother of the husband is also there, and she happens to be a greedy lady, and it doesn't matter if she's greedy or not, she will jump into the picture and she'll say, yeah, this hair looks very good on you. तू तो इसको घुमा देगी. Let me keep it in my custody. Whenever you need it, I'll give it to you. Common scenario? Agree or disagree? Please unmute yourself and say yes or no. Until unless there is too much of noise in your house, you can keep yourself unmuted. Okay. So, what next? Even if this is not going to happen, the bride is new in the house and she says, you know what, I don't have a locker, I don't know where to keep this expensive jewelry, blah, blah, blah. Mummy ji, why don't you keep it in your custody? Mummy ji is very happy. So Mummy ji takes that 10 lakh का हार कि अच्छा मेरी सास ने इसको बचा के रखा था, अब ये मैं रख लूंगी. अब पता नहीं ये शादी चलेगी नहीं चलेगी, क्या होगा क्या नहीं. All that drama happens. So now wife has noticed that I was giving a har. Somebody has also clicked the picture of this ceremony. Maybe she put a live show on Facebook. Maybe she recorded it. She clicked a selfie with it. Whatever, something has happened. In the next moment, she sends it to the entire gang, wherever, her friends or relatives or anybody. Uska ek kya ban gaya? What happened now?
Evidence.
Evidence ban gaya. An occasion like this happened. My dadi gave me a gift. Sorry, my husband's dadi gave me a gift. It happens to become a Sridhan. So I was Sridhan ban gaya, and soon after, my mother-in-law, I gave it to my mother-in-law to keep it in a safe custody. Now what is happening in this transaction? Whose property it has become at 8:30?
The married girl who has come to the family.
Correct. It has become a property by way of what? What is the transaction? What is the nature of transaction?
Gift.
Gift. It is not a sale, it's a gift. Gift to the bridegroom. Sorry, bride.
The property as a trustee.
Trust has not happened yet. Dadi has only gifted the property to the bride.
Dadi has gifted the property to the bride. The bride has
As of now,
the bride has given the property to the mother-in-law.
not yet.
Okay.
So the transaction between Dadi and bride is limited to
A gift.
a gift. That's the name of the transaction. Right? So because he has to claim it. So the evidence that it is a gift, not a sale transaction, not a theft, not a sale, is that video she has made right now. Dadi giving her the video. Maybe the husband was very excited. वो बहुत प्यार करता है अपनी इस बीवी को, कल को प्यार खत्म हो जाएगा जब वो 498 का केस डालेगी. So husband is very excited and he posts the video on Facebook and where not. Look, my lovely Dadi giving a नई generation करेगी ना ये सब हरकतें. Giving a 10 lakh heart to my love of life and blah blah blah. He's an idiot. He's doing that. So they're mutually creating evidence. हो गया? Next moment, because the mother is not very happy with her roaming around with this 10 lakh har in the house, and she says, you know, it could be stolen. Let me put it in my locker because I am the only one who has a locker. Or maybe this was all happening early morning, and the mother says, you know what, you do not have a locker in the bank. Let me take you to my bank, State Bank of India, Kodak Bank, Oriental Bank, Axis Bank, whatever bank she has a locker in. Once you have a locker of your own, I will give it to you. Do you think the bride is going to refuse? She could.
Believing the person would give the property.
Even if she doesn't want to give it to her wholeheartedly, but because everything is very nice right now, everyone is in love and everything is sweet, she will act all that nice bahu and she will say, okay, mummy ji. Agree? Now, she is aware where this har is. She went with the mother-in-law to this particular bank. Agree? What transaction has happened at this moment?
Trust. There is
Entrustment.
no breach of trust. 406.
No breach of trust has happened.
Later on.
Entrusting your belongings in somebody else's dominion. It is not in my power and possession anymore. Me, the innocent bride, has given it to my lovely mother-in-law. What I have done, I have entrusted my property. Did I tell that moment that, oh mother-in-law, I am giving you as a gift? Did I do that?
No.
I did not. There is no evidence to that. What I'm doing is, in a mutual agreeable environment, congenial environment, as a matter of trust, because my mother-in-law is like my mother, I am entrusting my expensive belonging, which has just become my belonging 5 minutes ago, to a third person in some kind of a fiduciary relationship. Understood? What I have established?
A fiduciary relationship.
With who?
With the mother-in-law.
With my mother-in-law. Who else I could have established this fiduciary relationship with?
Husband.
Husband, father-in-law, husband, brother-in-law, sister-in-law, anybody in the house. Maybe there was no mother-in-law. She's blind. She doesn't exist. She died. Something of those lines. है ना? Husband बोलेगा अरे तू तो इसको घुमा देगी मैं अपने लॉकर में रख देता हूँ. ठीक है जी रख दो. I agreed. I gave it to. So there is no element of it that I asked or you asked. We agreed to do it together. Now you know where that particular property is gone and parked. Maybe the mother-in-law takes you to her bank, Axis Bank, whatever bank she has a locker, early morning, 10 in the morning, with a fear that some thief will barge into the house and is going to steal it. In order to prevent that theft, robbery, whatever, She takes you to the bank and she does in front of you. You've been witness to it, correct? Now you know which locker it has gone to, on which particular date. So what do you know now? Today, 23rd June 2023, 8:30 p.m. My nani, my husband's dadi gave this particular gift to me. So you are putting an ingredient into your FIR. Please and try to understand why these ingredients are important. That how did you become the owner of that property? The second important thing in the transaction is at what point, what time did you give dominion or develop the fiduciary relationship with the third person? And where is it lying right now? This should be the actual chain of transactions, but that's not what happens in the real life. अब इसके बाद क्या होता है? 6 months passed by, 1 year passed by. The wife doesn't like the husband. Love is gone. Some quarrel happens. She goes and she approaches the lawyer or police or महिला थाना, whatever. महिला थाना भाई बोल क्या क्या ज्वेलरी तेरे को सीजन में मिली है. अब वही सब कुछ बताएगी. मेरी दादी उसकी दादी ने मेरे को 10 लाख का हार दिया था. मेरी मम्मी ने 50 लाख की ज्वेलरी जो शादी में चढ़ाई थी वो भी मेरी सास के पास है. मेरे हस्बैंड ने जो मेरे को हीरे मोती नीलम टर्कोइज व्हाट नॉट दिया था वो भी मेरे सास ने ले लिया. सम 1 करोड़ की ज्वेलरी इज लाइंग विद माय सास. ठीक है. But she doesn't remember the dates. Half of the jewelry doesn't exist. Blah blah blah. Maybe no jewelry ever came from her house to the in-laws' house. That's a reality. Now, and when she left home, acha, the third element of criminal breach of trust is you should ask it back. Let me simplify the concept a little bit for you to understand in the context of matrimonial dispute. It is a little complicated, but please try to understand. Harish owns a car. Harish and Gopal, they live in the same city. Harish has to go to Dubai for a month. Okay? Harish is scared. He lives alone in his apartment or wherever he lives. That if he locks his car and disappears for a month, his car could get stolen. Understood? Harish and Gopal are best friends. Harish asks Gopal, Gopal, can you please keep my car for a month? I will come back from Dubai and take it from your dominion. Gopal says, fine. Harish airport जाने से पहले गाड़ी उसके घर में पार्क करके उसको चाबी दे जाता है. Okay, what kind of relationship are they establishing right now?
Fiduciary.
Interesting dominion of
Fiduciary
the property.
relation. Property comes into the dominion of Gopal Srinath Kidambi. That's how I pronounce the name?
Kidambi, sir.
Kidambi.
Kidambi.
You're from Andhra, right?
I'm from Telangana, Hyderabad.
You're from Telangana. Okay.
Telangana.
You don't like to be called Andhra right now anymore.
Not really. Telugu is Telugu.
All right. So now Gopal says, after a month, Harish comes back and he says, Gopal, can I have my car back? Gopal says, bhai, tu kaun hai? Who are you? What car are you talking about? I don't know any car. Abhi,
So
what
may I
stupidity Harish did is, while giving him the car, he did not make any video. He did not make any written transaction. Look, I'm giving the property in your dominion and kindly return to me when I come back, so on and so forth. Will you do that in normal day-to-day course?
No.
Gopal will get upset. What are you talking about, man? Please give the car to somebody else. Hai na? So, because it's a friend level relationship, Harish believes Gopal is not going to break his relationship or a 5 lakh or 10 lakh rupees car, he's going to give it back. But Gopal turns out to be a dishonest man. Or he has some kind of an emergency in the family, he sells that car off. या वो क्या करता है, वो बोलता है कि किसी चोर को पकड़ता है, वो बोलता है कि देख ये गाड़ी है, ये चाबी है, उसको चुरा ले, उसको बेच दे, and give me some money, give me 90% of the money. Possible, because Gopal is not in position to sell that car on his own. उसके पास ना papers है, ना उसके ऊपर उसकी कुछ वो है, वो या तो उसको scrape करा सकता है, उसको चुरवा सकता है. He gets what he wanted to get. Now what has happened when Harish has come back and asked Gopal of returning his own property to him? What has happened now?
If he has refused to return the property, then it is criminal breach of trust.
Now the breach of trust has happened. He has not only refused to return the property, he's also misappropriated it.
I have a query, sir. If there is refusal of giving the property back, can misappropriation be presumed?
Yes.
It can be presumed? Okay.
Even if the misappropriation has not happened, but the refusal itself is going to invoke criminal breach of trust.
Okay.
And if see, again, whoever being in any manner entrusted with property or with any dominion over property dishonestly misappropriates or converts to his own use that property, or dishonestly uses or disposes of that property in violation of any direction of law, prescribing the mode in which such trust is to be discharged, or of any legal contract, express or implied, which he has made touching the discharge of such trust, or willfully suffers any other person so to do, commits criminal breach of trust. It has a very wide ambit. So basically, you've done something which you were not supposed to do. आपने मेरा ट्रस्ट तोड़ दिया. मैं आपके पास 2 लाख रुपए रख के गया था, जब मैंने मांगे तो आपने मुझे देने से मना कर दिया या आपने उनको बेच के खा गए. This is criminal breach of trust. Understood? I entrusted something, you refused to give it to me. अब स्त्रीधन के एग्जाम्पल में हम बात बताते हैं. Let's come back. You understood the concept of 405 and 406? Understood? Because if this IPC is not there, then everybody will start. कोई किसी पे ट्रस्ट ही नहीं करेगा, मतलब कोई लॉ ही नहीं है. People will just take your things and run away. So what happens now? In context of Sridhan, the moment this FIR is registered, maybe the mother-in-law will start moving around that property from that particular locker. She will take that house from that locker because it's her locker. When the police actually goes and opens that locker, nothing is found. समझ रहे हो? So she has actually sold off that heart, misappropriated her. This is what commonly happens in matrimonial disputes. Now coming back to the original, how this FIR is registered and what is important is, and what doesn't happen in real life is, जब लड़की नाराज होके जाती है, तो वो कभी भी मांगती नहीं है वापस. This is where the case falls flat. ना तो वो FIR में ये लिखवाती है, I'm sorry for the ones who do not understand Hindi, the bride does not mention a particular date when this particular property was entrusted to the in-laws. Nor does she mention in the FIR when did she ask back. Nor does she file any evidence. Because in real life, when the matrimonial dispute happens, the girl is not aware of the law that, okay, you need to ask it back on a particular day. So if the law, what we do generally is, I will send a legal notice. I will send a legal notice if a person has breached my trust in order for me to take a first step towards registering the FIR. All right. So I will send a legal notice saying, look, Gopal, I gave you a car on so and so date. Or look, mother-in-law, I gave you my har on so and so date. You kept that har in this particular locker on so and so date. Kindly return it to me. I need it now. For whatever reasons. That is an essential ingredient for you to be able to be successful in IPC 406. That is the difference between a good lawyer and a bad lawyer. A bad lawyer does not properly write that FIR. He doesn't write how did you get the entitlement, ownership of that property. He doesn't write when did the entrustment happen. He doesn't write when did you ask it back. These are the three key important ingredients for you to be able to fly your case in court of law. If you miss out, you have no case. And that's the reason acquittal in 406 happens left, right, and center. Courts are confused, lawyers are confused, police is confused. Even in High Court, you hear arguments. Usko dowry articles return karao, dowry articles return karao, wo sab kuch return kara rahe. Because it is so complicated for the courts to establish, for the IOs to establish, for the families to establish कि भाई क्या gift है, क्या interested है, क्या non-interested. It is very complicated, right? Because all that happened during happy days. And everything is in possession of the mother-in-law somehow. How are you going to distinguish? And by the time these FIRs are written by bad police, bad lawyers, bad counselors, they're not going into the nitty-gritties of the law. उनको तो कॉन्सेप्ट भी नहीं समझ में आता, वो तो बस ये लिखवा देते हैं अच्छा मेरी ज्वेलरी इनके पास है और वो लड़की से बोलते हैं कि प्लीज गिव द लिस्ट ऑफ द ज्वेलरी व्हिच इज इन द पोजेशन ऑफ योर मदर इन लॉ. तो वो 1 करोड़ 1.5 करोड़ का बिल बना के वकील साहब के हाथ में दे देती है कि ये सारी ज्वेलरी जो है मेरी सास के पास है. डू यू थिंक इट्स अ वाइज आइडिया टू डू दैट? It's bullshit. The court say, look, I don't think 1.5 करोड़ की ज्वेलरी तेरी सास के पास है. पहले तो तू बता कि 1.5 करोड़ की ज्वेलरी तेरे पास आई कहां से. अब जो अच्छे लॉयर्स नहीं है वो क्या करते हैं, वो ये दिमाग में डालते हैं क्लाइंट्स के कि जब आप बोलेंगे कि 2 करोड़ की है, 3 करोड़ की ज्वेलरी है, तो क्या होगा इसका इफेक्ट, लड़का डर जाएगा, वो हमको इतनी ज्वेलरी देनी पड़ेगी. But that backfires. किसके पास है इतने पैसे? मिडिल क्लास फैमिलीज में कि 1.5 करोड़ 2 करोड़ 3 करोड़ की ज्वेलरी आती है आपके पास. वैसे आपके पास खाने के पैसे नहीं है, वकील को देने के पैसे नहीं है, ज्वेलरी आपकी 2.5 करोड़ की जाती है ना. Doesn't match. So you need to actually establish realistic pleadings. That's when your case is going to fly in the court of law. Yes, Mr. Srinath.
Sir, now basically there should be a demand with regard to the property that was entrusted. Only then there should be a demand with regard to the property that was entrusted to the other person. Let's say mother.
Demand by who?
Demand by the person who entrusted the property.
Eventually, yes.
Yes. Now, if the demand is not made, the case fails. If in case
there is no case if there is no demand.
If there is no case. Now, let's presume that there was no demand, and the accused takes a defense that there was no demand, and therefore will not return. Can the court direct in that circumstance to return the property then?
He will not be convicted.
He will not be convicted. So if I file a false case of enrichment of property, it is better to deny that than to state that there was no demand.
Okay, I'll tell you what happens in real life. So this FIR is registered now. Okay? Even in FIR, all the girl is going to say कि मेरा सारा स्त्रीधन मेरे in-laws के पास है. You understand Hindi, na, Gopal? Okay. There is Nandini, you also comfortable, right?
Sir, you said something for me?
Yeah, are you understand Hindi or it's going?
I understand Hindi, sir. Clearly, I understand, sir.
All right. Where was I? Yes. So what happens now? In normal course of action, 90% of the FIRs are going to say, मेरा स्त्रीधन मेरे ससुराल वालों के पास है. उन्होंने ले लिया, मैंने मांगा, उन्होंने दिया नहीं. That's one line. अब होता क्या है? She left the house. It's sort of contradictory. अब contradictory क्या है? Because the concluding FIR, what the conclusion of the FIR is going to say, कि लोग इन्होंने रात को 12 बजे मुझे लात घूंसे मार के घर से बाहर निकाल दिया. कैमरास प्लीज. इन्होंने लात घूंसे मार के मुझे घर से बाहर निकाल दिया. अब जब मुझे घर से बाहर निकाल दिया, तो अब डोंट यू फाइंड इट एक्सट्रीमली प्रिपोस्टरस कि रात को आप 12 बजे जब आपको घर से बाहर निकाल रहे थे वो लात घूंसे मार के, उस टाइम आप अपनी ज्वेलरी वापस मांग रहे थे. एक तरफ तो you're trying to be an abla nari who was thrown on the streets in the middle of the night for whatever reason, or you went on to commit suicide or something. On the other hand, you were all being that bold and asking your in-laws to look, return my jewelry right now. Can't go hand in hand, na? So ideally what should have happened is when you went back to your matrimonial home, you should have sent a text to your mother-in-law, husband, father-in-law. Look, all this jewelry is lying with you. I gave you on so and so date. Now please return it. That would satisfy the second part of the criminal breach of trust, but doesn't happen in real life. ना तो lawyers suggest करते हैं और FIR और जो complaint in the heat of moment लिखा जाता है, वो that is written without this ingredient asking back. Now, what happens in due course of time is CAW cell mediation happens. At this point in time, it's a conciliation effort. Parties say कि इतना सामान है, उतना सामान है, ये दे दो, वो दे दो. So at this juncture also, there is no clear distinction of what is Sridhan and what is not Sridhan. What do you think is girl's state of mind right now after she's been cheated in this happy relationship? She thought when a girl gets married to a man, she wants to get married only once, until unless she's a habitual person who wants to marry 10 times. It's a practical thing. Nobody wants to get married 10 times. She gives her heart and soul into her first marriage, right? She was not expecting it is going to fall out tomorrow. So उसके पापा भी गिफ्ट्स दे रहे हैं फैमिली को, उसकी मदर भी दे रही है, वो भी दे रही है, रिलेटिव्स भी दे रहे हैं. There's a lot of gifts which exchange hands. Now, if she's going back to her mother's house, this marriage is breaking down. What do you think is her state of mind related to all these gifts?
Sir, like she wants a payback. She wants a payback.
She wants everything back. All that love, all that gifts, every affection, the suit she gave to husband, वो 10,000 का BlackBerry का सूट था, 20,000 का Versace का सूट था, whatever. She wants that back. अच्छा, I on this occasion gave you this. I on that occasion gave you this. My brother gave you this. My uncle gave you this. Give me all that back. मेरा शादी में 20 लाख लगा था, एंगेजमेंट में 15 लाख लगा था, ये लगा था, वो लगा था, वो पूरा बजट बना के वहां पे दे देगी. Agree? That's how humans behave, right? Emotions gone, love gone, then the money talks. That's how the life is. That's what happens during mediations in CAW cell. So it's a negotiating table. They're not saying कि स्त्रीधन वापस दे दो, ये दे दो, वो दे दो. वो एक ओवरऑल बजट बनाते हैं बोल के कि पैसे दे दो, इतने दे दो, 50 लाख दे दो, लेट्स कॉल द मैरिज ऑफ, वी आर नॉट गोइंग टू फाइल एनी केस, 1 करोड़ दे दो. अब आपको क्या लगता है कितने केसेस में हस्बैंड मान जाता है 1 करोड़ देने के लिए, 50 लाख देने के लिए? यस guys, talk. I don't like this mute and
Very rare.
very rare. Why? Because आप जैसे वकील हस्बैंड से बात कर लेते हैं, है ना, और हस्बैंड से बात कर लेते हैं बोल के कि तू पागल है क्या, 50 लाख रुपए देगा, मैं लेके आऊंगा उनको टेबल पे, मैं तेरी सेटलमेंट कराऊंगा 10 लाख में. होता है. What is the vested interest of a lawyer?
Peace.
Peace, of course. And why does he like this proposal?
He gets a case.
Yes, he says 40 lakhs. It's lucrative offer. And you are going to do your best to get him. He doesn't go to jail. You'll tell him कि तू जेल नहीं जाएगा, मेरी जिम्मेवारी है, कम से कम मेंटेनेंस लगेगी, वो 3 साल 2 साल में थक जाएगी, मैं उसको इतना थका दूंगा, मैं ऐसा कर दूंगा, मैं वैसा कर दूंगा, so on and so forth, और blah blah blah. And this is don't worry, है ना? Everybody wants to save their money. What do you think is the wise lawyer going to tell her?
So can you repeat that question, please?
What do you think is the wise lawyer going to tell the wife?
I'll get you the best deal.
I'll get you the best deal. हम इसकी मोटी मेंटेनेंस लगवा देंगे, मैं सुप्रीम कोर्ट तक जाऊंगा, मैं 1 लाख रुपए महीना जब इसको देना पड़ेगा तो ये ऑटोमेटिकली टेबल पे आ जाएगा, ये हो जाएगा, वो हो जाएगा, right? Both of them give pump to their clients. That's a normal scenario. What does courts do?
They do realistic assessment of the liabilities and income.
तो जो इंसाफ की देवी का तराजू है वो कभी लड़के के पक्ष में होता है, कभी लड़की के पक्ष में होता है, तो दोनों कंफ्यूज रहते हैं कि किसके पक्ष में. ठीक है, वो ऐसे ही चलता रहता है. So if both the parties are great or good lawyers, it's going to be an insane litigation. This case, that case. Matrimonial case में ना ट्रायल नहीं चलता कभी.
What did you say? It's going to be what litigation, sir?
Heavily contested litigation.
Okay.
If both the parties are from good families and both the parties are a little bit ladaka, then it is going to be a heavily contested case. समझ गए? दोनों ही वकील हैं, अब दोनों को ही अपनी पार्टीज को बेस्ट रिजल्ट्स लेके आने हैं. सो मैट्रिमोनियल केस में कभी ट्रायल नहीं चलता, उसमें सिर्फ इंटरलोकेटरी एप्लीकेशन डिसाइड होती है. कभी एग्जीक्यूशन, कभी ऑब्जेक्शन, कभी सेशंस अपील, कभी हाई कोर्ट अपील, कभी सुप्रीम कोर्ट अपील, कभी ये कभी वो. So both the parties are at war, and especially it becomes an ego battle. So now going back to 406, if you are in mediation, the conciliation things will happen. If you're a smart lawyer, what we do at this stage, we say, अब क्या है कि आप, if you're representing the wife and you know that you want to invoke 406 subsequently, eventually in FIR, it is a good idea to send a legal notice. Or ask the wife to send an email or WhatsApp message. Look, all this property is in your dominion. Kindly return it to me. तो आपने अपने पूरे इंग्रेडिएंट सैटिस्फाई कर दिए, फिर एफआईआर रजिस्टर कराइए. और अगर आप हस्बैंड को रिप्रेजेंट कर रहे हैं एंड cases have just begun, there is mediation going in CAW cell, wherever, send a legal notice to the wife saying, look, this happened, that happened, marriage was solemnized on so and so date, My client took you to honeymoon to England. He got you a Versace bag. He bought you this. He got this. Blah 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 blah. आपने client की खूब सारी उसमें तारीफ लिखोगे, ठीक है? And on so and so date, you got upset on so and so petty issue, and you left the matrimonial home. Now, soon after you started filing these frivolous complaints, which has no basis to it, my client, because you are legally wedded of my client and he understands his responsibility and he still loves you and blah blah blah, despite all of your dirty actions, in all the bona fides, I want to return all your belongings to you, which are lying in my house. ठीक है, आप शादी नहीं तोड़ रहे हो, आप ये बोल रहे हो कि I want to return all my belongings to you because you might need them. You're not living with me anymore. So there is a bed which you brought with you. There is a wardrobe. There is a refrigerator. There is an AC, whatever it is. And maybe, a few makeup is lying in my house and there is few jewelry in my possession, whatever it is. Please come and take it. Or tell me where do I park it. आपने क्या बोल दिया? आपने अपनी बोनाफाइडी दिखा दी कि मेरे पास ये सामान पड़ा है तेरा और मैं तेरे को रिटर्न करना चाहता हूँ. अब वो क्या है कि अब लड़की वालों को समझ नहीं आता कि क्या करे, because they want to harass you in the court of law. है ना? They are not very interested in that 2 लाख 3 लाख का कचरा जो उसने शादी में खरीदा था और उसने आपके घर में डाल दिया, जो भी कर दिया. उसको तो आपको कोर्ट में नचाना है. उसको तो उसके वकील साहब ने बोला कि 50 लाख दिलाऊंगा, 1 करोड़ दिलाऊंगा. तो उसके वकील साहब भी थोड़ा सा बौखलाते हैं कि क्या करें. तो दिस इज गोइंग टू सेव योर मेल क्लाइंट इन फ्यूचर. तो जब CAW सेल की हो रही है बात या जब FIR की इन्वेस्टिगेशन हो रही है, तो आप क्या करेंगे? इफ यू आर रिप्रेजेंटिंग अ मैन, you are going to take that legal notice and give it to the police till the time of investigation. देखो भाई, हमने तो इसको नोटिस भेजा था, ये लेने नहीं आ रही है. I am still okay if you please come and collect the stuff. आपकी 406 नहीं लगी. और अगर वो पुलिस एविडेंस नहीं ले रही है, जो लीगल नोटिस इज द लीगल एविडेंस. You send it through registered post, you send it through WhatsApp, email, blah blah blah. It's a lawyer's document. If the police is not taking that evidence, go to magistrate. Tell the magistrate, look, my client had, he has registered a case in 406. My client had voluntarily offered before this registration of FIR. Please ask the IO to do the fair investigation. वो तो ले ही नहीं रहा है. Magistrate will direct him to take the notice on the record. समझ रहे हैं? तो आप इसको अगर टेक्निकलिटीज के साथ खेलेंगे तो other party won't know what to do. But the problem in this country is people don't understand the law and then everyone sings their own song. But when the matter actually goes to the court of law, you need to prove 3 ingredients. When was this Freedhan entrusted? What was the proof of ownership? The proof of ownership is, yes, you owned this stuff at one point in time. That's very important. So in the Dadi's case, the proof of ownership became that video which I viral while Dadi was giving me the gold set. Alternatively, the proof of ownership is going to be my mother purchased it from whatever jewelers in South X or Karol Bagh. This is the bill. This is the date. She gave it to me on so and so date. Then proof of entrustment. When did you entrust this material to the mother-in-law? The thing has to exist. You have to show to the court, look, something like this existed. It was in my possession. I entrusted it to my mother-in-law. I asked back. So there is a sequence which you need to fulfill in order to complete the entire transaction under 406. Otherwise, it's useless. Yes, Mr. Tandon.
So you talked about WhatsApp message, then legal notice. Now, let's say you're representing the wife side. A lot of times they may not have the evidence and all. Legal notice se aap ye to you'll say ownership, entrustment, and please give my property. 3 things you say. But how do you prove it? ये तो बड़े लिमिटेड केसेस ऐसे होते होंगे ना कि वीडियो बना के भेजा दूसरे केस के वो
तो तभी तो प्रूव नहीं होता, तभी तो प्रूव नहीं होता कुछ भी. आप लंबी चौड़ी लिस्ट थी, इट्स ऑल डराना धमकाने वाला सिनेरियो. There is no legitimate evidence.
Similarly, from the boy's side, if he says I am ready to give it back, वो list पकड़ा दे 10 items की making it 50 lakh, whereas they have hardly given 5 lakh हिसाब किताब. Then
नहीं,
so how
husband is not going to do this. Husband is going to do something which cannot be misappropriated. अभी क्या है, जब शादी हुई थी तो एक ट्रक भर के आपके घर सामान आया.
Sorry? Yeah.
When the marriage happened, truck full of goodies. That includes a refrigerator, AC, bed, gadda, blah, 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 blah. Right? It's not easy for you to misappropriate it, and the valuables are not worth much money. Agreed. And obviously, the girl would have picture of these stuff. But what has been fed into her mind is that you claim that you have given a 50 lakh jewelry. Where is the real money? Real money is jewelry, not this kabada.
And actually, when she leaves the home, she can't be taking immediately refrigerator or gadda and all that. Le jao abhi.
So you as a husband is going to claim, look, all this stuff is lying in my house, you take it please. But I don't have any jewelry as you claim, because this is utter nonsense.
Now this he has to do post receipt of WhatsApp message, legal notice, or on his own.
She has to do it on its own. But if the matter reaches court of law, like let's assume she's telling the truth. Okay, let's just stick to this Dadiwala incident. The moment she leaves the matrimonial house, or after 1 month, 2 months, whatever, she needs to ask it back. Now, if there is an evidence that she had the dominion, she had the ownership of the necklace, there is an evidence of the entrustment, there is an evidence of this particular necklace going to the bank because there is a CCTV camera, locker was opened on so and so date. Chain of transaction, chain of custody is not being deviated. Thereafter, when she asked, look, my necklace is lying in the bank, kindly give it to me. Then the reverse burden of proof goes on the mother-in-law if she doesn't return. फिर उसकी बैंक स्टेटमेंट लॉकर ओपनिंग की डिटेल्स निकल जाएंगी. Did she open the locker after marriage broke down or whatever happened, the girl left the house? तो मैजिस्ट्रेट क्या है, मैजिस्ट्रेट आयो परमिशन लेगा कि मुझे लॉकर ओपनिंग की डिटेल्स निकलवाई जाए. So the burden of proof at the moment is on the girl that misappropriation has happened. समझ गए मेरी बात? If she is able to discharge a proof to a point that, look, the custody of necklace was given on so and so date, I only happened to ask this on so and so date, and meanwhile she has not returned me anything.
I've got a point here, sir. See, the point is that she makes a claim. I had given the custody to my mother-in-law, now she is not returning back. And let's say mother-in-law actually goes, she's got certain stuff also in bank and locker खोलती है, वापस लेके आती है, अपना सामान ले आती है. Now CCTV footage is generally stored for 15 days. The incident, she makes a claim after 6 months. Year later, magistrate orders that. So CCTV footage तो मिलेगा नहीं उसको. So now how can she may keep claiming anything?
हाँ, so it depends
So
कि
case
how
is
far.
case is going to fall flat.
Exactly. That's what happens in most of the cases now, because the girl is not able to prove the chain of custody. But now the point is, if uh, if when the returning happens, ठीक है, अगर लड़की ने आपसे ज्वेलरी बीच में मांगी है, ठीक है, मान लीजिए आपने लॉकर बीच में खोला है, मैरिज फॉल फ्लैट नहीं हुई थी, तो देन यू हैव अ केस टू से कि look, I returned this necklace to her and thereafter it's not come back to me. किसी की शादी हो रही थी अगले दिन, तो उसने मुझसे लॉकर खुलवाया पहले दिन और वो ले गई, उसके बाद उसने दोबारा मुझे इंटरेस्ट नहीं किया. बात समझ रहे हो? That's going to be your defense. But if from that day to that day locker is not opened, so what police generally does is they seal the lockers as soon as 406 is filed. So what happens in normal course of action, like all of you are lawyers, it's a complicated proposition. आप आधों के उस सिर के ऊपर से जा रही है बात, तो आप ये समझिए कि आम आदमी को कैसे समझ में आ जाएगा how to misappropriate the jewelry soon the matrimonial discord happens. Not everyone does that. You understand? So what police does is, police seeks the permission from the magistrate and they seal the locker. See, my jewelry is lying in so and so locker, I be given the permission to seal it. And that locker should be allowed to open only in front of me or both the parties. So then, mother-in-law is in a suit. बात समझ गए? एक बारी 406 रजिस्टर हो गई, पुलिस ने लॉकर सील करा दिया, mother-in-law was not able to take out the necklace from the locker. It opens in front of the police and she has already refused returning that Sridhan to the girl. Then locker अगर return करा लिया, seal करा लिया, and it opens in front of police and girl and everybody, and that jewelry comes out, then mother-in-law is in a suit. Police will file a charge sheet saying jewelry was found lying in the locker and she refused it. पकड़े गए आप? रिकवरी हो गई ना उसकी? समझ गए हैं? ये अगर दादी वाला केस है तो इसमें आपकी शॉर्ट शॉर्ट कन्विक्शन है. अगर ये दादी वाला केस नहीं है, सिनेरियो 2 लीजिए, लड़की बोली है कि मैंने अपनी एफआईआर में मैंने अपनी सास को सोने के 10 बिस्किट्स दिए थे. समझ गए? कोई एविडेंस नहीं है, कोई फेसबुक वीडियो नहीं है, कोई व्हाट्सएप पिक्चर, कुछ नहीं है. It's just a bold allegation. I gave 10 biscuits to my mother-in-law. Now she happens to ask it back. Mother-in-law refuses. Now what mother-in-law is going to say is, she knows that it's in her possession. There are 10 Sone ke biscuit lying in a locker. But what defense mother-in-law is going to take at the moment is, they don't belong to you. They belong to me. I purchased them. समझ रहे हो? It's a he said, she said situation. So the first ingredient is going to come back in the picture, wherein how did she acquire ownership of those Sone ke biscuit? That's the first evidence she needs to produce to the court in order to claim ownership of those. तो दादी वाले केस में तीनों चीजें एस्टैब्लिश हो गई. एक तो I acquired it in form of gift. First thing done, tick mark. I gave it to the mother-in-law in front of everybody, tick mark. Then I asked from mother-in-law, she refused to return it. tick mark. It also got recovered from the locker. आपने चारों चीजें satisfy कर दी है. अगर आप चारों चीजें satisfy कर पा रहे हो तभी conviction होगी. मगर अगर सिर्फ बहू बोल रही है कि सोने के बिस्किट मेरी मदर इन लॉ के लॉकर में है और मैंने दिए थे, अब मुझे वापस दिला दो. So the burden of proof is on the daughter-in-law to prove when did you buy those सोने के बिस्किट? How did it become your property in first place? Because tomorrow she can claim everything lying in the locker is hers. You understood? In order for you to satisfy all the four ingredients, you have to start from कुछ ना कुछ गड़बड़ होगी घर का. या तो ownership disputed होगी, entrustment disputed होगी, रिकवरी डिस्प्यूटेड होगी. अगर एक भी चीज डिस्प्यूटेड है तो कन्विक्शन नहीं होगा. एनी डाउट्स? यस मिस्टर सिन्हा.
So may I?
यस प्लीज.
Okay. So basically, with regard to what you had said earlier, demand notice is sent either by the wife or the lawyer on behalf of the client, and the mother-in-law who has been entrusted the property with replies to the legal notice saying that this is the Sridhar, I am willing to return it. Right? If in case you don't reply to that legal notice and 406 gets registered, can you state in the court that yes, this Sridhar, I am willing to return it, would still lead to conviction?
नो.
So even if I don't reply to the legal notice and it goes to court, and in the court I say, yes, this Sridhar, I'm willing to return it now, there won't be a conviction.
See, legal notice, I'm going to, if I'm sending the legal notice from a husband's side, I'm going to say, look, this is property lying in my possession for 15 days. Okay, come and take it. If you don't come and take it in 15 days, then you lose right over it.
That is not what I'm saying, sir. We don't reply to the legal notice at all.
You start afresh. You start afresh.
Okay, so the wife sends a legal notice.
Okay.
You reply to the legal notice. Section.
Husband doesn't reply.
Yeah, husband doesn't reply. Husband or mother-in-law or any of the in-laws don't reply. Okay, it goes to court after the police registers 406. Can I take the difference in the court that yes, this amount was received as Sridhar, I am willing to return it now. I had no intention to misappropriate the property. I genuinely believe that the matrimonial dispute would get resolved. Can I take the difference?
Yeah, but then that is a hidden intention of yours, na? Why were you keeping it when she asked?
So even without replying also, it becomes misappropriation of property. Even if I don't convert it into my own use, even if I just
your intention. See, okay, forget this. See, relationship. You are bringing emotions into material. Okay, it's a fiduciary relationship. Forget about that she's a wife or daughter or whatever it was. You are thinking that it might resolve tomorrow and you'll be able to enjoy the ownership of that which does not belong to you. That's what your intention is, ना? आप उस रीजन को क्यों रखना चाह रहे हो? आप सोच रहे हो कि चीजें रिजॉल्व हो जाएंगी तो I don't have to buy new furniture. You understand? Somewhere you have a hidden agenda that is going to hurt you. So you should never do that.
okay.
So let the Sweden go back to her house. If things are going to resolve, let it come back if it needs to come back.
One more query, sir. This was one case that I dealt with a long time back. It was a dowry case. Okay. To the best of my knowledge, I don't believe there was a formal demand or anything. Okay, but we stated that it was Sridhar and we are returning everything now. Is that a valid defense?
I don't understand.
Okay, so the wife alleged dowry. Okay, The defense that was taken is this was Sridhan and it is her property, or we are willing to return it back to her. Is that a valid defense?
Yes, you can. When you say it was never a dowry, it was Sridhan. अगर वो dowry उसको allege भी कर रही है तो फिर आप dowry prohibition act में giving dowry is also crime, taking is also crime. But she has to show the coercion, na?
Yes.
She has to prove that dowry was demanded, and that's when we did it. So the burden of proof of dowry is hers. I don't have to even take a defense.
Okay. Okay.
So that's what happens in 498A and difference between dowries, Sridhan and gifts. In 498A, nothing exchanges. Okay. So जब dowry है या 490 कुछ भी और out of coercion दिया गया है, उसको आप वापस नहीं मांग सकते. That's what people don't understand. You can't ask gifts back. You can't ask dowry articles back. Do you understand? It's a penal offense. ये जो recovery होती है, it is only a standard operating procedure. It's done in goodwill. You understand? It's not legally allowed.
It is an illegal transaction.
It's done in a goodwill. अब recovery जो होती है उसको इतना टेक्निकल बनाने के लिए मान लीजिए आप अगर रिकवरी 406 की एफआईआर हो गई है, you have explicitly refused a particular belonging that it does not belong to me, and police happens to find out and happens to recover it. That's when the case is made. Otherwise, there's no case made. These recovery of dowry articles or Sridhan is a routine recovery. It's not implicating you. आप अगर CAW सेल के उसमें बोल रहे हो या जब आपको FIR रजिस्टर करी गई हो बोलते हैं कि आपके पास क्या क्या सामान है आप बता दो, you make a list and you say कि मेरे पास ये सामान है. समझ रहे हो? आप अगर उसको रिकवर भी करा दे रहे हो, नॉर्मल रूटीन में क्या होता है? A girl doesn't send you a legal notice. Police says कि we want to recover the dowry articles, we are coming to your house and we want to do recovery. Let them recover whatever they want to recover. What is your defense? It was never demanded. When did I misappropriate? It's all lying in my house. There is no 406 ka case.
And there's no formal demand either.
There is no formal demand. There is no misappropriation. I did not run away with that material. This is one scenario. Compared to a scenario where she claimed ownership, entrustment, your refusal, plus police eventually finding it in your house. समझ गए? और police finding it in some कबाड़ी की दुकान. Then they go and inquire कि भाई तेरे पास ये कहाँ से आया? Chain of events. We purchased it from this family. Police reaching an ornament shop, finding out that you sold this particular necklace on so and so day. That is misappropriation. But ये सब evidence आता नहीं है ना चालान में. आप तो कुछ misappropriate कर ही नहीं रहे हो. आप तो सब कुछ दे दे रहे हो जो आपके घर में है. एक बारी पे मांगने पे. तो जब evidence in chief होगा bride का, तो in her evidence in chief it is very important for her to mention कि मैंने फलाने दिन मांगा, फलाने दिन ये मेरी ओनरशिप थी सामान की, मैंने फलाने दिन मांगा, मैंने दिया, मैंने फलाने दिन वापस मांगा, इन्होंने रिफ्यूज कर दिया, so on and so forth. But all has to come in evidence in chief. Now, what is going to be your defense as a defense lawyer? You're going to say, ma'am, this is the FIR. I don't see you mentioning anywhere in the FIR that you entrusted all this property on so and so date. You understood? You have to contradict her with her previous statements.
Why is it important to state that you did not entrust all the items?
You did not entrust anything.
You did not entrust anything. we deny the allegations basically, right?
You did not mention it in the FIR that you entrusted so and so thing. It's an afterthought.
Okay.
All the previous statements, can you tell me on which date do you entrust this material? Can you tell me from where did you buy it? Do you have any evidence of entrustment? Did you send any WhatsApp message? Did you send any text message asking it back? She's going to say no. So you're going to ask all these questions.
Okay, got it. Thank you, sir.
ठीक है, तो वो ingredients उसको establish करने पड़ेंगे. That is entrustment. Okay, enough of explanation. I'm going to share some judgments in order for you to understand what how it works. Okay. Okay, can you see the screen? Yes? Anybody?
Yes, sir, visible.
Yes.
Okay.
Yes.
Okay. Sushmita, please read the part B of this. I'm just going to say B.
Yes, sir. See? Penal Code 1860, Section 405 and 406, Criminal Breach of Trust, ingredients or prerequisites for offence of whether made out at stage of framing of charge, entrustment of any property or misappropriation to or by in-laws found lacking, held charge under Section 406 not made out.
Oh, 1 second. हाँ पढ़ते हो जाओ. This is Omkar, not Mishra, right? Sorry. इसका पैराग्राफ 18. Read, Sushmita.
In the present case, from a plain reading of the complaint filed by the complainant on 18/11/1994, extracted above, it is clear that the facts mentioned in the complaint, taken on their face value, do not make out a prima facie case against the appellants for having dishonestly misappropriated the freedom of the complainant, allegedly handed over to them, thereby committing criminal breach of trust, punishable under Section 406 IPC. It is manifestly clear from the afore extracted complaint, as also the relevant portion of the charge sheet, that there is neither any allegation of entrustment of any kind of property by the complainant to the appellants, nor its misappropriation by them. Furthermore, it is also noted in the charge sheet itself that the complainant had refused to take articles back when this offer was made to her by the investigating officer. Therefore, in our opinion, the very prerequisite of entrustment of the property and its misappropriation by the appellants are lacking in the instant case. We have no hesitation in holding that the additional sessions judge and the High Court erred in law in coming out to the conclusion that the case for framing of charge under Section 406 IPC was made out.
All right. समझ गए? Gyan, para 6. Please read.
To constitute the offence under Section 406 IPC, there must be clear and specific allegation that the accused was entrusted with some property or domain over it by the complainant, that the accused has dishonestly misappropriated or converted the same to his own use, or that accused refused to return back the articles when the same were demanded by the complainant. Perusal of the allegations appearing against the petitioner do not show that the articles of Sridhan were even entrusted to her. In the absence of the allegation of entrustment, question of misappropriation or conversion to her use does not arise. Thus, the most vital ingredient to constitute the offence under Section 406 IPC is missing. In view of the above, no case under Section 406 IPC is spelled out against the petitioner.
So guys, what is happening in these two judgments? What is court saying? इसमें बोल रहा है perusal of the allegations do not show the articles of Sridhan were even entrusted to her. So prima facie entrustment के allegations ही नहीं है. Forget about misappropriation and asking back. So the first thing you need to satisfy is कि entrustment ever happened. ये कुछ cases में prima facie entrustment ही missing होती है. It's very specific. In the absence of entrustment, question of misappropriation conversion to use does not arise. So in order for you to satisfy 406, forget about the dominion. Dominion could be proved in the trial. Entrustment and asking back is very, very important. समझ गए? आगे बढ़ो.
So what is the name of the second case, sir?
I will share all these judgments with you. इसमें आप चलो नोट करना है कर लो. ये अनुगेल वर्सेस स्टेट है, हाई कोर्ट ऑफ दिल्ली का है. 99. Para 6. I have a little compendium of these paragraphs noted. I'll share this on the group. Acha. This is the third judgment. Right. Rajkumar Khanna versus NCT 2001. लिख लिया? Okay, para 29. Where are you located, Jina?
Sir, Bombay High Court, sir.
How do you pronounce your name? Jijina.
Jijina, sir.
Okay. RD is your complete name? Or?
AD. Adi. 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 It's Adi. Pronunciation is Adi, sir.
Adi Jijina.
Yeah.
What community are you?
Parsi, sir.
I see. How come you don't have a Baba accent?
That is not so.
And you're also not generally hyper. 29. All right, please read 29, Suspata.
Admittedly, neither the complainant nor the supplementary statement show any entrustment of any property to the petitioner. In the absence of entrustment, question of criminal breach does not arise since there was no entrustment of any articles to the petitioner. Therefore, chances of ultimate conviction on this count are bleak. No useful purpose is going to be served by allowing the proceedings under Section 406 IPC to continue against this petitioner. In support, reference can be made to the observations of Supreme Court in the case of Alpic Finance Limited versus P. Sadasivan and another 2001. Apex Court, while dealing with the inherent power of the High Court to quash the complaint and proceedings, observed, having regard to the facts and circumstances, it is difficult to discern an element of deception in the whole transaction, whereas it is palpably evident that the appellant had an oblique motive of causing harassment to the respondents by seizing the entire articles through magisterial proceedings. We are of the view that the learned judge was perfectly justified in quashing the proceedings, and we are disinclined to interfere in such matters. Reference can also be made to the observations of Punjab and Haryana High Court in the case of Lakhvinder Singh versus State of Punjab, where it is held that an FIR is liable to be quashed if it does not contain specific allegations of either entrustment or of cruelty. Courts have consistently put an end to criminal proceedings at the initial stage, at the summoning stage, and even after charges have been framed, which are abuse of the process of court. High Court has the inherent power to quash proceedings and to pass such orders as are necessary.
That's fine. That's fine. ये बटन डाल दे देना. ये हो गया. All right. This is not relevant right now. Okay. Varla Bharat Kumar and another versus State of Telangana and another 2017. All right. Para number 9.
The ingredients of criminal breach of trust are also not forthcoming from the records as against the appellants. The allegations contained in the complaint and the charge sheet do not satisfy the definition of criminal breach of trust as contained in Section 405 IPC. In view of the blurred allegations, as we find that the complainant is only citing the incidents of unhappiness with her husband, no useful purpose will be served in continuing the prosecution against the appellants. This is a case where there is a total absence of allegations for the offences punishable under Section 498A and Section 406 IPC. In the matter on hand, the allegations made in the first information report, as well as the material collected during the investigation, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute the offences punishable under Section 498A and 406 IPC against the appellant accused. So also the uncontroverted allegations found against the appellants do not disclose the commission of the offence alleged and make out the case against the accused. The proceedings initiated against the appellants are liable to be quashed.
The uncontroverted allegations are very important. Something that is not being contradicted, prima facie, they do not establish a offence, वो quash हो जाता है. ठीक है? I see a new person. All right, so this is I'm going to close.
Sir, name of the judgment, please.
1 second. This is Roshan Lal Raina versus State of Jammu and Kashmir, 1983. इसमें ना, this is they've taken 1 second. Okay. So basically, this judgment, I'm going to share this judgment to you. Read it. It's about a government office where money was entrusted to one of the employees, and then it was alleged that he misappropriated it. It's a 2-page judgment only, but it's a little complicated. आपको एकदम से समझ नहीं आएगी. I'm going to share it to you, but it's basically what was held was that entrustment of money to accused was not proved on facts. Okay, why this is 409? 409 में ना government officers आ जाते हैं. जैसे 408 is criminal breach of trust by a clerk or servant. 409 is criminal breach of trust by a public servant or by a banker or a merchant or an agent. ठीक है? These are not per se directly used in matrimonial disputes, but कई बारी use भी हो जाते हैं. Like sometimes the bank does some kind of a fraud in a matrimonial dispute. They breach your trust. They leak out some information which they were not supposed to, so on and so forth. So this context made it good to understand. So this is related to 409, but they basically explain the entrustment. So why he was acquitted? Because entrustment of money could not be proved. So what I'm implying here is, in order for you to convict somebody in 405, so on and so forth, entrustment has to be proved with the facts and the evidence. तो अगर आप entrustment ही नहीं prove कर पा रहे हो, तो आपकी conviction नहीं होगी, चाहे recovery भी हो जाए. समझ रहे हो? तो सारे इंग्रेडिएंट satisfy होने बहुत जरूरी है. That's what this judgment is all about. I will share it, read it later on. उसके बाद one more important judgment is okay, this is done. I will share all these judgments for you, don't worry. Okay, this is State of Gujarat. Can you see? State of Gujarat versus Jaswant Lal Natalal. Okay. ये सुष्मिता 8 points से read करो.
Entrusted found in section 405 IPC governs not only the words with the property immediately following it, but also the words or with any dominion over the property occurring thereafter. See Velji Raghavji Patel versus State of Maharashtra. Before there can be any entrustment, there must be a trust, meaning thereby an obligation annexed to the ownership of property and a confidence reposed in and accepted by the owner or declared and accepted by him for the benefit of another or of another and the owner. But that does not mean that such an entrustment need conform to all the technicalities of the law of trust. IPC Jaswantrai Manilal Akhne versus State of Bombay. The expression entrustment carries with it the implication that the person handing over any property or on whose behalf that property is handed over to another continues to be its owner. Further, the person handling over the property must have confidence in the person taking the property so as to create a fiduciary relationship between them. A mere transaction of sale cannot amount to an entrustment. It is true that the government had sold the cement in question to BSS solely for the purpose of being used in connection with the construction work referred to earlier. But that circumstance does not make the transaction in question anything other than a sale. After delivery of the cement, the government had neither any right nor dominion over it. If the purchaser or his representative had failed to comply with the requirements of any law relating to cement control, he should have been prosecuted for the same. But we are unable to hold that there was any breach of trust. A case somewhat similar to the one before us came up for consideration before a division bench of the Calcutta High Court in Satyendra Nath Mukherjee versus Emperor. These are the facts of that case. One Satyendra Sundar Mitra was a contractor. He was granted a permit by the executive engineer, ARP Shelters Construction Division, to purchase 7 tons of cement from Balmer Lorry and Company. The permit was granted on the condition that the cement was to be used in the work connected with the construction of shelters, which work he had contracted to do for the executive engineer. The finding in the case was that with the help of an employee of Mitra and Chaudhary, who were Banians of Balmer Lorry and Company, 6 tons of cement were diverted and disposed of for another purpose. The trial court convicted Satyasundar Mitra under section 406 IPC and another for abetting the offence committed by Satyasundar Mitra. The High Court followed their appeal, holding that there was no entrustment of the cement in question within the meaning of the term as used in section 405 of IPC. In the course of the judgment, it was observed the permit was granted in accordance with the system of control established under the Defence of India rules, under which an order has been issued by the Government of India preventing selling agents such as Balmer Lorry and Company from delivering any cement except under instructions from the government or from the cement advisor. The transaction, so far as the contractor is concerned, was one of purchase, and the property in the cement clearly passed to him. No doubt he could not have obtained the permit through the executive engineer if it had not been intended that the cement should be used for the purpose directed by the engineer. But in our opinion, in no sense it can be said that there was any entrustment either of the property or of any dominion over the property. We are of the opinion that the legal position is as explained in that decision. The decision of the King's Bench Division in King versus Grubb, relied on by Mr. Debar, learned counsel for the appellant, does not bear on the question under consideration. Therein the factum of entrustment was not in dispute. The only question of law that arose for decision in that case was whether when a property is entrusted to a company and the person directing and controlling the company by whose instructions the property had passed into the possession of the company had converted the same fraudulently, that person can be said to have committed an offence under Section 1 of the Larceny Act 1901. The court answered the question in the affirmative. In our view of our conclusion that the prosecution has failed to prove the entrustment pleaded, it is unnecessary to consider whether on the material on record it can be concluded that the respondent had misappropriated 40 bags of cement referred to earlier. In the result, this appeal fails and the same is dismissed.
All right. So what these last 2 judgments were talking about, they were basically what confusion was. So there had been a sale transaction between the 2 companies. Okay. The sale transaction out of some guidelines. For instance, I say I'm going to sell 40 packs of coffee to Mr. Tandon, which I procure from Karnataka. And Mr. Tandon is only going to sell those particular coffee in his coffee shop, which is located in a particular mall in Dehradun, so on and so forth. Okay, this is the commitment I have with him. This is an agreement I have with him, sort of a specific performance. In return, Mr. Tandon gives me money for those 40 kgs of coffee or tons of coffee or whatever it is. This is a sale transaction. It's not entrustment. And Mr. Tandon, what he does is, he, instead of selling that particular brand of coffee in a particular shopping mall, he chooses to give 40% of it to a different vendor. Let's say he sells it to Cafe Coffee Day or Starbucks or whatever. And because he thinks that he doesn't, itna sale nahi ho raha hai karke. I can't sue him in criminal breach of trust. समझ गए? 405 नहीं invoke होगा because it's a pure sale transaction. On the contrary, I gave him 40 bags of coffee to keep him in his godown to protect from the pest, or I don't have a godown, on a fiduciary relationship. Saying I'm going to come and take them, or just keep it in your godown. Let me say I've rented a godown for 2 months. And when I go and ask him, okay, I need to send this docket to Hong Kong. Kindly give me those 40 bags. He says, what 40 bags? Do you think criminal breach of trust will happen now?
Yes.
Understood the difference? So this is what these two last judgments are trying to say. So was selling of sale fee under some guidelines and implied conditions, which can happen, which happens in businesses all the time. But that's not criminal breach of trust. That'll be violation of certain guidelines or fraud or blah, blah, blah. But that's not purely criminal breach of trust. This is what Supreme Court has tried to explain in these two judgments. So I hope you have understood the concept, if you have heard me properly, and I was able to make myself clear. If you have, of course, there's no time left to discuss other sections. If you have any questions related to 406 or any other thing which we have discussed in past, please shoot. Rest of the sections I'm going to take in the next class. Or if you're all bored, then you can call it a day. Itna silence.
Sir, I have a query, but not in relation to section 406. Will you be covering how a person can get custody of a child?
How he can get a custody of child?
He or she.
What do you mean?
A married couple, they have a child. They have disputes, and subsequently one parent wants custody of the child. Will it be, let's presume that Hindus, it will be covered under Hindu Minority and Guardianship Act or Guardianship and Wards Act?
Ideally, Guardianships and Ward Act. I'll read with Hindu Minority and Guardianship Act.
Okay.
So there are only certain sections which you're going to take from Hindu Minority and Guardianship. Rest is Guardianship and Ward Act, which is a general act.
My question is, sir, the mother and father are already national guardians of the child. So why would guardianship come into picture when it comes to custody?
Okay, it's a topic I'm going to cover in detail. All I'm going to tell you right now is there is difference between guardianship and physical custody.
Exactly. So will you be covering this in the future?
Yes, of course.
Okay.
Once I finish this IPCs, so my subsequent topics is going to be domestic violence, 125, Guardianship and Wards Act in detail.
Okay.
So if you want me to start Guardianship and Ward Act once I finish the FIR business, then I can do that.
Yes, sir. I don't know if that is going to be covered, sir. That is all.
I'm going to cover the entire matrimonial litigation. I don't want to rush things because then it gets stressful. I want to take this one session in a week works perfectly fine because I'm not stressed, you're not bored, because the ones who wants to join can join, because 2 sessions I think that's too much, and it also disrupts my routine. So I think this works perfectly fine. We're going to work on a slow pace so that we actually learn. We just don't rush things.
Okay, sir. Thank you.
Yeah. If any questions, any general questions, if none, yeah.
I have got one question, sir. Not with what you have covered today, sir. A very peculiar situation. So you have said, all that what you be covering in matrimonial dispute. I've come across a case where it has happened that the girl was pregnant, she delivered the baby, the in-laws, including husband, the parents of the girl came to know pretty late that they have become virtually bankrupt, and the admission to the hospital was denied. You see, some emergency for her, whatever cesarean operation or whatever. Anyway, the baby was delivered and all that, but the health became so bad, she was virtually close to death. Now the stage has come in. They want to seek a divorce if you could not look after a daughter. This is the betrayed our trust, and उसके नाम पे काफी कुछ, I think, I believe कुछ किया हुआ है, what do you call that ना, उसके person's name पे कुछ लोन उठाया होगा, जो भी कुछ है, लोन कह रहा तो somebody had contacted me. So I said classically it doesn't fit into any of the grounds of a divorce also, and I really don't know what can you do
नहीं,
about it.
classically तो cruelty तो बनती है अगर
This I did tell him, cruelty, because it's a total indifference. Now it depends how well you can convince the court. Because और कोई section तो बनता नहीं. Cruelty
so get the medical
indifference that
report.
you can't earn that much of money also, and you are so indifferent. You don't even tell the family of the girl also. This is the stage the girl has reached into. And
अगर financially bankrupt
she gradually opened up. When condition became so bad, they just called up the parents. This is then she was not telling initially. Later on, it happened.
So medical documents.
You can't the hospital also for negligence and all. So
just need to collect the medical documents where she's vitamin this deficient, that deficient. She was verge of collapse. She was not being fed well. It's a entire chain of events that's going to build up your case.
And what about the boy side? They say, sir, actually we wanted to, but we were bankrupt. We didn't have the money.
इतनी कितनी money? सरकारी अस्पताल ले जाते हैं?
Yeah, that's what I was thinking. But
every city has a civil clinic which gives you free medicine to women.
Yeah.
मेरे घर के पास ही है, मैं भी पैसे बचाने के लिए वहीं चले जाता हूँ. It's nearer to any other private hospital. Doctors are all sane, man. So they don't charge a penny. It's a big deal. All for my flu shots and rabies vaccine and all that, I just go there. What's the big deal? So, I mean, that's fine. But that's how
thanks for your answer, because it actually on these lines only I advised it. I said
that's the only possible.
Only mental cruelty, provided you are.
It's mental and physical. आप DV Act पढ़ेंगे ना, तो आपको ये वाला जो एरिया है आपको और ज्यादा उभर के साफ आएगा.
नहीं, लेकिन एक बात है ना सर, DV Act में तो you'll ask for maintenance this thing, but they are wanting to get separated, and whosoever contacted me, they said, the thing is mutual. They will never go. The other party will never go for mutual. So I said it's going to be contested, then mental cruelty is the only.
What I am trying to tell you is you will get the ingredients how to draft your case
out of DV Act.
Yes.
Yeah.
Because it talks about in detail all these negligences So if the legislation has taken them on the face value, okay, these are negligences, it falls into some kind of a cruelty, either physical, emotional, mental, financial, then it is a cruelty. And then you can take it to the civil court. समझ रहे हैं? So the initial distinction we established was cruelty in relation to 498A case, divorce case, domestic violence. Everything has a different level. So DV वाली cruelty definitely divorce में काम करेगी.
Second thing, sir, in your classes, you will be covering up in detail the stages of how does the mutual divorce happens. First motion,
तो
second.
बहुत complicated नहीं है सर, 10 मिनट का काम है, बता देंगे.
ठीक.
मैं सब कुछ बताऊंगा, आप अपने आप से टॉपिक्स लाते रहना, बट मोटा मोटा I'm going to cover DV Act. Is any of you taken a DV Act course separately?
Sir, I've taken the DV Act course, but I'm yet to begin it.
Sorry?
I have enrolled for the course, but I'm yet to begin it.
Started watching the recordings.
Sorry, sir?
You are going to start watching the recordings now.
Watching the recordings, yes.
Okay. I'll be taking it from a different perspective. I'll be taking it more from the okay, whatever. I'm not going to be going into so much of detail as ma'am did, but I'll be covering it because it's part of the entire matrimonial disputes. Okay. That's it. Adi, what do you practice? Like, are you solely in High Court or what is your?
Yeah, I practice in the lower court too, sir. Basically, 100% the criminal side, sir.
100% in criminal side.
Yes, sir.
Mostly in the High Court.
High court, lower court too. Mostly ABA and BA.
Sorry?
Mostly ABA, sir. Anticipatory bail application, sir.
Okay. That.
So by that, matrimonial cases is also adjoined with that. So therefore, I'm coming here.
I see. I hope you are getting some useful information.
Yeah, definitely.
All right. Thank you, guys. We call it a day, and I'll see you next Friday. And please join 5 minutes before 8 o'clock. And tell your other colleagues also to join because I don't like an empty class. Thank you. Bye.
Thank you, sir.
Thank you, sir.